Welcome back to all. I am Vidhu Kishore. Let me introduce myself again. I am a BLLB from Amity University, Jaipur, and LLM from National Law University, Jodhpur, in intellectual property rights. Today we will be discussing about the concept of intellectual property right, the classification, industrial property, literary property, copyright, patent, trademark, and industrial design. So, moving so the concept of intellectual property. In general, we know that the property exists in two ways, that is movable and immovable. Movable that can be moved, and immovable that cannot be moved from its current location. And both these properties exist mostly in tangible form, that it can be seen and touched. Intellectual property, on the other hand, is a part of the intellect of an individual, meaning that it is intangible, cannot be seen or touched. It's an idea or a piece of information that is created within the intellect of an individual and is transferred in the form of an object or a property. Once this object or a property comes into existence, the ultimate owner becomes the person who created this object or property, hence giving him the right of utilizing this property or object to his or her benefits or any way they want. Basically, the most important part about intellectual property is that the idea that gives rise to the creation of this particular property, giving importance to the intellect of an individual in which the idea is created, and from that idea it becomes a certain amount of like an object, design, it could be anything, but the importance is of that idea that basically is created in the intellect of an individual, and the execution of that idea becomes a property which ultimately creates a right in the owner. Moving on, the classification of intellectual property is quite simple. Now, intellectual property can be divided into an industrial property or a literary property. And the industrial property exists of a patent, trademark, and industrial design. Literary property, on the other hand, exists of copyright and neighboring rights. Industrial property. Now, industrial property is basically a property where we are using it to indicate a property, intellectual property that can be used for industrial purposes. Here it can be design, it can be trademark, it can be a brand or trade names. Now, the object of industrial property is basically conveying information to the particular field of consumers about the product, about any kind of brand or object that you go out in the market to buy. And whosoever misleads a consumer regarding the same information is the one that violates such industrial property. So in general, here we are talking about the industrial use of intellectual property and what kind of properties that can be included in this category. So as I've told, it is basically patent, trademark, and industrial design, which I'll be discussing further in this lecture. Now, literary property, as the name suggests, is the rights related to literary work of any kind. For example, novel, music, videos, and the right exists in the author, the writer, or the creator of that music video. And here basically the main right is the copyright, which is included in this particular literary property. Also, there is performer's right and neighboring rights, but the copyright is the main intellectual property that is included in literary property. So the objective of literary property is to protect the author's personal interest and individuality. Now, moving on, first intellectual property that we will be discussing is patents. Now, what are patents? Patents are basically rights that are given to the owner of owner who has actually made any inventions or any process of inventions. So this invention or a process of invention that is being done by this particular individual, the rights of this particular individual are protected through patents. Now patents are like are like documents, and these certain documents are issued by the government to this particular individual who has basically invented any kind of object or is involved in the invention process, basically giving them the right that no other person will be allowed to either duplicate that process of invention or duplicate his invention in the market, basically giving him the monopoly of that particular product that he has invented on his own. So patents are basically issued by the government on the given three conditions that we will discuss in detail further. First is novelty, second is industrial use, and the third is an inventive step. In short, I can tell you that novelty means new or certain kind of new invention in itself which is unique. Industrial use means that it can be put in the market for any kind of industrial use, that it has an industrial use, that the object is not completely useless in any manner. And inventive step is that it involves a step or a process which basically creates an invention that can be used further for the betterment or development of humankind. So the patents are issued by the government, and the protection is always obviously given by the certain government of that country to the person who has invented that product. Now the patents can be given on two different types of products. First is basically on the process, so that is a process patent, and second is the product. So if you're involved in the process of making a new product or new let's say a new kind of medicine that can cure cancer, so that will be your process patent. Or you have basically invented the last product is a medicine that can cure cancer, so you can apply for a product patent. So as the name suggests, process and product. Now here I have given you an example of like a jacket which has a unique holder, if you can see here, and this is kind of a drawing that is basically first presented to a patent controller. One of the documents will be this drawing when you first apply for a patent, and this drawing will be depicting all the unique aspects of this particular product and why this particular holder is important, and why this jacket is very different or unique from the other jackets that are there in the market. And as I told you, novelty, industrial use, and inventive step. So the novelty is the jacket design is new. The inventive step here is the holder, and the industrial use is that it's a jacket and people wear it around the market, and it basically has a market use. So that is how you will see basically a patent drawing in an application for patent. Moving on, this is the basic patent application which is applied upon the website of World Intellectual Property Organization, WIPO. Now WIPO is one of the most important organizations in the world when it comes to intellectual property rights. This is the only organization to whom you will apply if you want any kind of intellectual property to be registered internationally. Now, as you can see here, this is the international filing date. International filing date is the date on which the patent was applied in the country of its invention. Like if I have invented something in India, so 14 February 2017 is the date when I have applied the patent in India, and the same date is being used by me to apply an international patent, let's say in Singapore. So this is how I will be applying my international patent application, and this is what it basically looks like on the website. A very important example this whole thing is, because this is major when it comes to all the law firms around the countries and internationally how they work. This is the very basic application that you need to know how to read when it comes to really working in the corporate world. So this is a important example of a patent application. So this is how it looks internationally, worldwide, everywhere. A patent application on a WIPO website will always look something like this. So just this is just an example. As you can see, the filing language is English, publication, priority dates, priority data is another big huge deal about patents, which we will be discussing when we discuss patent in details. Now moving on. Trademark. So what is a trademark? A trademark is a type of intellectual property right consisting of a recognizable sign. Very important, a recognizable sign. As you know, that trademark exists in many forms. It can be an expression, it can be just colors, it can be any kind of data that is seen on a product, which makes you identify that product from the other products in the market. So trademark is basically, it's like a unique mark that you create upon your product to identify it in the market from the other ones. And that is why trademark is actually used. It is used to recognize a product in the market from the other product, and basically it provides you the protection against the use of the same similar sign, similar expression, similar piece of information that you're putting on your product, so that no other company or no other competitor in the market can put the same sign or expression on their product. So there shouldn't be any similarity. So there can be many types of trademark. One of the basic trademark is a service mark. Now service marks are basically used by hotel or restaurant. Service marks means the trademark that are indicating any kind of service. So obviously a hotel or a restaurant or an airline, usually they are going to use a service mark because they are providing a service. Commercial name, designations, trade names, these are also used by enterprises and corporate companies. Now this is the basic example of trademark and service mark. As you can see, trademark is here on your left. So this is like Nike. Just do it is also an expression that is completely theirs and it is protected by them. Now just do it cannot be used in any other form by any other company in the product of making shoes. Like Nike, their basic is sports shoes, and we all know that. Now Nike's black sign of this, as you can see, this part is completely protected. The way the font of Nike and the black of Nike is protected. Just do it, again, as I told, this expression is protected. Maggie's font and size, the color that they are using, that is red and yellow, the way they are using it, like a splash and a kind of a object, kind of a shape here. Now this shape cannot be used by any other noodle or instant noodle making product. Now this is completely their unique symbol, which helps a consumer know that this childhood favorite brand is available in the market by this name, and the way it looks is like this. So the recognizable sign is the basic part of a trademark, that when you can recognize the product, the one that you know like or want to buy in the market. Apple, very famous in itself, it's now a brand. The trademark is this particular half mooned apple. That is the basic trademark now, which is being misused, as we know, but obviously this is their territory, and this cannot be copied by any other company that uses mobile phones or uses electronic gadgets. So yeah, this is the basic Apple, the Apple signal that cannot be used by any other electronic company. McDonald's, again, very very famous. There, this M sign is very famous, and again cannot be used by any other restaurant or a food chain. Adidas, Coca-Cola, we all know about this. Now this is a service mark, which is basically indicating Prudential's service mark. Everybody knows about the ICICI Prudential services, and we know what they do. They provide insurance on health insurance, other insurances. So this is their logo. So this is their service mark. Moving on. So I've given you like example of a registration certificate and how it looks like. I couldn't really get an Indian one, but I will put an example of an Indian one as well. This is basically United States of America, the first one that you see on your left. This is United States of America. A typical registration, trademark registration certificate will contain like the registration number, the category to which the trademark belongs. Here it is this service mark, as you can see, and whosoever is the in whose the organization's name, the Wholesome Nutrition Center, this is the name, and basically in who's the registrar and who will be the person in whose name the final registration will go, which the information is mentioned here in this certificate. Again, if I move to this registration, this is a trademark registration certificate for Singapore. Now it is being issued, the trademark number is here. The company's name here is not given, but it will be given like typically here, and the name of the property is whatever property it is. It can be a service mark, it can be something else, it can be a typical trademark, and also a sign will be always indicated, the symbol that they are going to protect. Now they have not given it completely for obvious reasons, but here will be the complete sign that is being applied for registration. So this is an example of a registration certificate. Now moving on, copyright. Now copyright relates to artistic creations such as poems, novels, paintings, cinematographic work, etc. Now copyright is basically used when it comes to literary creations, or as I told, artistic creations of any kind. Copyright is basically the right to copy. This means that the original creator of products and anyone they give authorization to are the only ones that have the exclusive right to reproduce the work. Copyright is intended to protect the original expression of an idea in form of a created work. Now the work is protected under copyright, but not the idea in itself. So example here is that if I am a director and I'm interested in making a movie out of a novel that I recently read. So I will ask this particular author to give me the authorization of replicating his literary work into the creation of a into creation of a cinematographic work, that is the movie. So that is how copyright works. The copyright can be licensed on, the copyright can be authorized of from the original author of the work. So that is basically an idea for you of how copyright basically works, and I will be discussing, obviously I'll be discussing this in detail as well. So this is an example of copyright work. The C that you are seeing here, this is how copyright is indicated on all the kind of art or artistic creations that are there in the market. And industrial design. The industrial design consists of a creation of shape or a pattern or color or combination of patterns that have an aesthetic value. Basically meaning that let's take an example like of a Bisleri bottle that you see in everyday life. Now the design of a Bisleri bottle is very different from any other plastic bottle that you will see in the market. Why? Now the aesthetic value or the aesthetic design of that Bisleri bottle is designed by an industrial designer. Now what does this person do? He will design this plastic bottle in a way that becomes unique to this particular product or this particular brand of drinking water. So the design on that Bisleri bottle becomes unique to that particular company, and that basically again it becomes recognizable to the consumer that this particular bottle belongs to Bisleri, and it can be differentiated from other plastic bottles. So as an example also, Alvaro Aalto was a renowned architect who has also designed a significant number of household items such as chairs, stools and lamps. Now moving on, this is an example that I've given you of industrial design. Now industrial design, basically as I told you, here also I've given you the example of a plastic bottle. It is depicted like this particular part of the bottle, the down part of the particular this plastic bottle, the bottom part where it is being uniquely designed by somebody, which is giving it a unique identity in the market, and it is basically made so that it can be recognized from other products that it belongs to a certain mineral water company or whatever use this plastic bottle is there for. So this brings us to the end of this lecture. Thank you all for watching. Please like and subscribe to this video, and do let me know of any queries from this session in the comment section. Please stay tuned for my next session where I will be discussing intellectual property in detail, where I will be discussing about trademark, about patent, about industrial design. I will be going into complete details of violation of the rights that are there in the intellectual property. So please stay tuned. Thank you so much.